May it please the court, counsel. My name is Martha Trout, and I represent the state of Iowa. The defendant manufactured a conflict of interest when she threatened the life of the prosecutor, and her actions should not have been rewarded. The entire Dubuque County Attorney's Office disqualified from handling this case.
You even have to back up. Is there a conflict of interest?
There is no conflict of interest, Your Honor. And to the extent that this court has recognized previously that there could be a circumstance in which a prosecutor may have a conflict based upon other relationships, that is not the case that you have before you. And so what the court hasn't had an opportunity to do is to determine exactly what is the standard or test by which a court should determine that a prosecutor is burdened by a conflict and no longer able to handle the case. So I think looking at other jurisdictions is insightful, and what other jurisdictions show us or tell us is that the conflicts or the nature of these conflicts fall into two categories. One is a prior professional relationship, which did not occur in this case. And the other is that there is some familial or financial or emotional relationship that might prevent the prosecutor from handling the case. That doesn't happen in this one either. What the defendant would like you to believe, however, is that the prosecutor has some type of an emotional tie, and that because her life was threatened, because she was called a derogatory name, that she can no longer handle this case or prosecute this case.
Well, I think the defense actually wants to recharacterize the issue. And the issue, as I read it, is the defense would like to say, look, we've got to focus on the bond hearing that resulted, and that was a way overreaction, that there was personal animus obviously going on. And in light of that, the district court said time out and decided that it would be best to have an outside prosecutor. So, I mean, I think the high water mark of the defense is not so much to focus on the mere threat itself, but the bond, the prosecutor's reaction to it, and that generated some personal animus, and that the district court, in its discretion, decided, look, we want a clean prosecution. We're not going to have a record that's arguably clouded by this unnecessary issue.
I disagree that this was an overreaction on the part of the prosecution for several reasons. First of all, the threat was made. The defendant was recorded because she was visiting her boyfriend in jail. She knew, and I believe, that it was an attempt by this defendant to manipulate the process. The prosecutor took the threat seriously, but not personally. And unfortunately, we don't live in an era or a time where it's safe for children to go to school or for us to go to the movies. What the prosecutor...
It could have gone the other way, but the district court was on the ground floor here, and I think our standard, you may, and I want to invite you to challenge me here, though the standard is clearly untenable. I mean, we try and vest, I think, a fairly wide discretion in the district court in these kind of matters, and we're sitting here on high, and so we're kind of sensitive to that. I understand the thrust of your argument, but drive home the point of why this is clearly out of bounds, please.
It's clearly out of bounds because the defendant created the conflict. And most courts around the country would say that defendants don't get to create the conflict and then have the prosecutor's office removed.
I think the district court, I could be wrong, and please, the purpose of this is to correct my misimpressions, but I think the district court viewed it not so much that there was a threat and that's an automatic disqualification. And I understand your point. If that were the case, every defendant could issue a threat and could use it as a tool in plea bargaining by thrusting more expenses on the state. And God, that doesn't make any sense. And I think that has that's a substantial point.
Well,
but the district court is saying, I think that there's more to it than just the threat here.
Your Honor, I think that when you look, you have to look at the timing of this. And clearly, the state moved to revoke the bond in May, and based upon the danger that it felt, the defendant presented to society. So the court revokes the bond and then increases it to $25,000 cash only. That happens on May 30th of 2014. The bond is subsequently reduced in August, and then there's a competency determination where the defendant is found to be competent and the prosecution can resume. It's not until October 24th that the motion to disqualify is filed. So some 5 months, almost 5 full months, have elapsed between the time that the state moves to...
But there really isn't any need to, because her competency's just been reestablished and now we're setting it for trial. There really is no need to file a motion to recuse the office because the prosecution is not proceeding at this
I disagree
point.
with that, Your Honor. The prosecution may have, the proceedings may have ceased during the pendency, but the prosecution did not end. This defendant still stood charged with a criminal offense.
Well, I understand that, but nothing's proceeding. Everything's just stayed while we're determining whether there's any type of competency. So nothing's happening other than the intervening things that we have here, which is the tape recording and then the reaction by the county attorney's office to revoke her bond.
Your Honor, but I think you also need to focus on what the prosecutor's statements were, because at the motion to disqualify, she said, if this had happened to any other member of the public, I would have done the exact same thing. It is not personal to me. And prosecutors have to have a thicker skin in order to do our jobs.
I do want to talk about that a little bit, and I think it does go back, and I do want to isolate between Ms. Barnes, I guess, in particular, and the whole county attorney's office, because I think they are separate issues to a certain extent. But don't you agree in reviewing that tape of, or the video of this whole interview, that perhaps increasing this woman's bond to $25,000 cash only could have been seen as somewhat of a punitive response by Ms. Barnes?
I disagree, Your Honor. I think that she presented a threat, and let's not forget that the underlying offense in this case is that she tried to attempted to or did disarm a peace officer. Clearly this woman is mentally ill. I think everybody would agree to that. But what the actions that she takes are somewhat, they're concerning. And what the prosecution did, in my opinion, was probably the least restrictive means possible to protect the public.
Is there a problem here? I mean, here's the thing. As I read this argument that's being made on appeal to defend the district court's order, the problem is it somewhat reads to me like a collateral attack on the order revoking the earlier bond, which wasn't appealed, and where the judge that set the higher bond, that was a different judge, and he presumably had all the information. If he thought this was retaliatory, he could have known that and declined to increase the bond. But now we have a different judge who has ordered a recusal, but the basis for the challenge is going back to what the prior judge did. Do you see where I'm getting at it all? I apologize, it's not really a question.
Well, but, and part of that too, Your Honor, is when you look at this, because her bond was subsequently lowered in August by the same judge who disqualified the county attorney's office. It was set at $10,000 unsecured. She was directed to the Department of Correctional Services, and she was told to maintain her appointments with her psychiatrist and submit to an evaluation. So, you know, to the extent that this might be a collateral attack on the bond, that's really kind of a non-issue, because 2 months after the order was issued, the bond is subsequently reduced, and she's out.
Let me try and get where I'm driving at a little better. It was a poor question or not a question. Isn't the defendant's argument really an argument that Judge Schubat erred in what he did with her bond? Isn't that what she says? The whole argument is predicated on the bond setting being an error. Otherwise, because if it was retaliatory, if it was an overreaction, he never should have done what he did, right?
Well, I don't read it that way, because I don't think that the court considered it or read it that way, because it called into question whether or not this prosecutor could go forward in a fair and just manner and prosecute this defendant without some type of a conflict, I would add, that has been manufactured by this defendant. But let's just say, for example, and I completely disagree that Bridget Barnes had a conflict in this particular case, because I don't think that there's anything from this record that would engender a finding that she had a conflict. I mean, she didn't charge any, there were no new charges that were filed. That, I think, might rise to the level of some type of vindictiveness or that she was, that she had overreacted. She tried to revoke, or she moved to revoke the bond. That was it. Her purpose was to get this defendant off the street. It wasn't to protect, and it was to protect the public.
Well, Ms. Trout, you acknowledged early in your argument that that this claim of conflict had an emotional component to it, and an emotion is a human response that's not readily picked up in a cold record. Shouldn't we trust the judgment of the judge on the spot? No,
Your Honor. What I said is that that conflicts can fall into two types of categories, and one would be an emotional conflict. And I maintained that the prosecutor did not have an emotional tie to this case, but that the defendant wants you to believe it. I'm sorry?
That's what the claim was, isn't it?
Right. But my point is that prosecutors have to have thicker skins, and we have to understand that we have an adversarial system. When charges are filed, people are not going to like the fact that they've been charged with a crime. And this defendant in particular, she didn't get what she wanted. And she's upset, understandably, with the prosecutor in this case.
Could you address the issue of whether the entire office should have been conflicted out?
Yes, Your Honor. To the extent that we don't believe Bridget Barnes had a conflict, but even if this court were to find that this threat then rendered her unable to prosecute this case because of some conflict, this conflict absolutely cannot be imputed to the entire Dubuque County Attorney's Office. And, Your Honors, one of the bases for the motion was that if you look at our rules of professional conduct, it was 32.1 sub 7. But when you look at that, when you talk about conflicts in prosecutors' offices or in government attorneys, the types of conflicts that apply are conflicts for current clients, which this prosecutor does not have, or former clients. Again, there's nothing in this record that indicate that that this prosecutor, who had never previously represented this defendant nor had any type of relationship, was burdened by the conflict.
What about the general concept of just the appearance of a conflict, or the appearance of bias, or the possibility, I'm talking individually, not the imputation to the whole office, so I'm going back to her, I guess, a little bit, that she may not, or it puts the whole process perhaps in a little different light, that maybe there wouldn't be plea offers in the future that she had in the past. Maybe there's all sorts of potential conflicts that may be there. Do we look at that at all?
Your Honor, when you look at cases around the country, it used to be like the line of cases in the 70s and 80s that it was the appearance of impropriety, because the two considerations would be fairness to the defendant and whether or not the public has confidence in the system. Courts since that time have backed off and say that the appearance of impropriety isn't enough. That's too thin for us to make the determination. So there has to be something more. And the burden would be on the defense to show what that something more is. And I think cases from Florida talk about a substantial prejudice, that unless this prosecutor is removed, that the defendant would not otherwise receive a fair trial. There's been none of that in this particular case. Getting back to your question, Justice Cady, about the imputation of the conflict, our rules of professional conduct relative to prosecutors and government attorneys it does not impute, at least 2 members of this court have found in a recent McKinley decision, that imputation of the conflict of a single person or a single prosecutor is not imputed to the remainder of the office. And I think that there's some very good policy, very sound policy reasons for doing that. The nature of our work is completely different. We don't have a financial interest. We're not paid by our clients. We have a statutory duty, and we have a duty to impart justice and fairly. Those types of things do not lend to the fact that if someone comes into my office who's burdened by a conflict, that I am no longer able to do what is my job. Notwithstanding the fact that, this could set a very dangerous precedent. Because when does it stop? You get the county attorney's office in Dubuque removed, then you threaten Alameda, then Johnson's put on it. It's giving these defendants way, way too much power to mess with our system of government and justice and preventing the prosecution from doing what they are statutorily required to do. And for this reason, Your Honors, we ask that the district court's order be reversed.
Thank you, Ms. Trout. Ms. Trevino. Welcome. I don't think we've had you in court before.
No, this is my first time. May it please the court? Counsel? The state would like this case to be about a defendant who creates a conflict of interest in order to forum shop for a prosecutor. This is not the case. In the state's narrative, the defendant, Corrine Erickson, is a mastermind who subconsciously induces a prosecutor to take action after making a statement.
Let me, I know it's your first time up here, but you probably were told we ask a lot of questions. Let me change the facts a little bit. Suppose the threat had been made toward Judge Shubat instead of toward Ms. Barnes, the prosecutor, all right? And otherwise the same facts. Would you be arguing here today? Wouldn't you be arguing here today that he needs to recuse too?
Well, not necessarily, Your Honor.
Well, what would be different about that?
The difference is that Judge Shubat did not make a motion to revoke Ms. Erickson's bond.
But he granted the motion.
He granted the motion certainly after Ms. Barnes filed that motion to revoke. Ms. Barnes, in her motion to revoke, specifically states the statement that Ms. Erickson made in that recorded phone call, that she furthermore inserts an emotional animus against the defendant.
Where's the evidence that this was an emotional reaction as opposed to a professional one?
Well, specifically in the motion, the county attorney indicates that the defendant calls her a cunt. Certainly, that in and of itself is not a threat.
But wait. I mean, frankly, it may have been direct and explicit in a historical report, but to historically report these kind of comments doesn't reflect personal bias, does it?
Well, she included it as a reason for her motion to revoke her bond. That certainly indicates that there is some sort of... It was
part of the raised jest. Here's a concern, and I realize that just about all the actors in this are women except for the 7 of us, but I'm concerned about sort of a sexism that might be underlying this issue. That is an assumption potentially that because the assistant county attorney was a woman, her reaction was an emotional one rather than a professional one. And isn't that a danger? And don't we deserve to shouldn't we be giving her the benefit of the doubt?
Well, perhaps. However, I do agree with the state in saying that prosecutors need to have a thick skin. Certainly, prosecutors probably get called worse, and I know the defense attorneys get called worse as well.
But let me go back to the standards. If you read the ABA standards on conflicts of interest for lawyers contained in the ABA standards for prosecutors and defense attorneys, the standard is a prosecutor shall not permit his or her own professional judgment or obligation be affected by his or her own political, financial, business, property, or personal interest. Now, where does this conduct affect this prosecutor's personal interest? I mean, because it's surely not political, it's surely not financial, it's surely not business, it's surely not property. So where does it affect this prosecutor's personal interest?
Well, again, the comment relayed by Ms. Erickson was directed, or was including Ms. Barnes.
Where is personal animus the same as personal interest?
Well, when you look
I mean, she has a duty under the law to prosecute this person, and she knows she's not going to be looked on nicely. I mean, is her personal interest to put this person away for a long time because she threatened me? I mean, that doesn't make any sense.
Well, Your Honor, I would disagree that this is even a threat in and of itself. The state itself cannot conclusively say that the statements made by Ms. Erickson was a threat. Specifically on the state's brief on page 9, the state cites, it is unclear whether the statement made by Ms. Erickson that whether it was a actual threat, a perceived threat, a hyperbole.
Right, but we live in a certain day and age. I mean, there have been, I can think of one incident where a litigant made a statement about me that I didn't view as a threat, but the staff here sure viewed it as something they needed to take action on. So, I mean, it seems to me it's unfair to downplay this kind of thing at the same time where we're constantly being told by the media and everyone else that we need to be vigilant about these kinds of things.
Well, it's correct that there was a motion to revoke her bond filed in May. At the initial appearance after that warrant was served on her, the matters of her bond were not addressed. Instead, what was addressed was her competency issue, which leads to that lag in time from the end of May until August 1st. On August 1st, then the matters of her bond were addressed. At that point, the Honorable Judge Ackley did determine that there was no conflict at that point. She again decreased her bond to a $10,000 unsecured, finding that there really was no threat.
But let's assume you meet the standards of the ABA standard, and I'm not going to concede that, but let's assume there is. We've had 2 to 3 cases in the last 5 or 6 years saying that when conflicts arise, you can screen. We've recently put out for publication a change to Rule 32.1.9, I think it is, that expands screening for attorneys in case there is a conflict of interest. So even if there is, let's assume there is, wouldn't the remedy for the court to be, if the court really felt there was some personal problem with this prosecutor, just to screen her out, and anybody else in the office could prosecute? I mean, it seems sort of drastic to remove an elected official who is elected by the people to do a certain job when there's other competent people in the office. I mean, how is it inconsistent if the judge would just screen rather than disqualify?
I think that would be an appropriate measure to screen attorneys whenever there's a possible conflict or if there's an appearance of impropriety. But in this case, that screening didn't occur. In fact...
but the judge could order the screening, because in the 3 cases we had, we ordered screening. I mean, the judge did it, and we ordered screening to take care of the conflict. And it goes back, I think Justice Strite wrote the first one almost 6 years ago. But the problem is, could it be an abuse of discretion for the judge to have a more drastic remedy that was necessary, even if we agree that he was the person on the ground, boots on the ground, I think someone called it here, determined there was an actual conflict or some kind of conflict? Didn't the judge go too far in their abuse of discretion standard just to say, get another office, get another county to prosecute?
It could be an abuse of discretion. However, in this case, I don't believe it is an abuse of discretion.
And tell me why not.
Okay. Well, there was, again, no screening procedures in place. No time did...
I'm sorry to interrupt you, but I'm having trouble seeing how there's anything in the record to support knocking out the entire office. I mean, there's actually literally nothing there. And isn't that tantamount to abuse of discretion? I mean, there's nothing in the record that suggests that there weren't prosecutors in the office that could handle the matter. I don't think. Help me if I'm missing something. But
It is correct. The order that recuses the county attorney and the entire Dubuque County Attorney's Office doesn't indicate why all the office is recused.
Not only does the order not indicate why, but there's nothing in the record to support the broad sweeping disqualification that I'm aware of, and help me if I'm missing something.
I do believe that trial courts do have that discretion. They are familiar with the local practices of the prosecutors. They also had the opportunity to view the defendant at the hearing. So I think they are the appropriate venue whenever there is a determination whether or not a county attorney's office or a county attorney should be disqualified.
Doesn't the district court have to have some kind of record, or if the district court's going to use his or her personal knowledge as to how an office works, include that in the order so we could at least review it? I mean, that's the problem, and maybe it's frustrating to me at least that, you know, you took an axe to something that needed a kitchen knife, you know, if it really was a problem.
Again, I would just ask that this court rely on the trial court's discretionary function. If we, at this point, tell the trial courts that all their discretionary decisions are going to be reviewed by the appellate courts, we're essentially eviscerating their entire discretionary purpose.
Could you address the state's argument that if we affirm this order that disqualified not just Ms. Barnes but the entire Dubuque County Attorney's Office, it's going to encourage other defendants in the future to make threats, just to interfere or to get a different prosecutor?
I absolutely agree with the state that no defendant should create a conflict of interest in order to disqualify a county attorney or an office. I think in this case, no conflict of interest was created by Ms. Erickson. Specifically...
well, she's the one who made the threat that was recorded on audio tape.
What I would disagree that it is a threat. Specifically, the words in this case do matter. If you look at the statement, it says, "I'm on the verge." It doesn't say, "I'm going to." It doesn't say anything else. Furthermore, no charges resulted as a result of those statements.
All right. So, and I will accept your characterization that the issue here is not the threat, but it's what happened after the threat. But tell me what happened after the threat. There was a bond hearing, of course, and the bond was increased significantly, and some pleadings were filed. But as I look at the pleadings, yes, they do use the C word, if you will, or whatever. You know, there it is, laid out. But it's factual, and the prosecutor takes the position that these kind of statements represent a threat, and the bond is increased. And later on, we have more process, but that happens all the time in our courtrooms. What was it about the bond process that waves this big flag? I mean, as I look at the four corners of the documents that were filed, I don't go, ooh. I go, well, maybe I go, ooh, and I look at some of the language. But in terms of the professional product that was produced.
Well, there's a lot of intricacies about this case, including competency. Ms. Erickson was incompetent to stand, not competent to stand trial since October 2012. At the time of the motion to revoke her bond, she was still under those proceedings. There is nothing in the record from Ms. Barnes to indicate that she was an actual threat to the community. The only thing that the state focused on was that actual statement, a statement that, again, the state does not even think is a threat per their brief. So in going off of that, there was multiple indicia in the record that tell us that Ms. Erickson is not a danger to the community. She had been on pretrial supervision since June 2011.
I know, but some of this is just relating to the merits of ultimate bond. I mean, if any of us had been the judge on the hearing of the bond, we might have said, well, you know, but as I look at the proceeding, there's nothing. I mean, what is it that says, oh boy, we got a personal animus problem here? The state takes the position that, well, she said these things and therefore bond should be increased. Maybe as a judge I'd have a critical eye on it, or maybe I wouldn't. I don't know for sure, but it just doesn't seem like there's a, you know, gasoline go woof here.
And that's correct. Again, I think that it falls back onto the trial court's discretion. The judge is very familiar with these prosecutors, very familiar with how that office works, and perhaps, and I can't speak for the judge since it's not specifically ordered, perhaps the judge didn't think it would be appropriate or that her bias in this case would then be imputed to the rest of the office. I can't speak for the judges, why the judge reasoned that way. In order to discuss Ms. Trout's timing issue of when the motion to revoke, to disqualify the county attorney was filed, I don't think that should bear any weight on this court. The point of the matter is that it was timely filed. So that should have no bearing on this decision here today.
You mean timely filed? I mean, ordinarily when there's a conflict, we want to get at it right away. Because if there is indeed a conflict, and if we do have to re-engineer the proceedings, we want to do it right now. And the bond hearing was, and I don't know the exact date, but the filing wasn't until substantially later. Yes, there was ongoing proceedings relating to competency and so forth, but the issue of a conflict was apparent, I take it, at the time of the bond proceeding, was it not?
I could agree with that, Your Honor. But the nature of litigation is such so that.
But if you're going to disqualify somebody, don't you jump right on it and not wait for 5 months and see kind of what happens and then file your motion?
Again, the proceedings were stayed. She was not competent to stand trial until October 20th, and the motion to recuse the county attorney and disqualify the entire county attorney's office was filed 4 days later. A hearing on that matter was then held per the court's calendar on December 11, and an order was then issued on December 15. I see that my time has expired. Thank you.
Thank you as well, Mr. Trevino. Rebuttal?
May it please the court? I just wanted to talk briefly about what the defendant is asking or what the defendant is saying now relative to a screening process. And I'm reading from the motion that she requests the county attorney and said office be recused in this matter and an independent prosecutor be appointed to avoid any potential conflict or perceived conflict of interest. And that's exactly what the court did in removing the entire county attorney's office. She comes before you today and she asks for a less restrictive means. That's not what she wanted. That's not what the district court did, and that's why we're here. The action that the district court took was an abuse of its discretion because it overreacted in finding that the entire Dubuque County Attorney's Office.
Would it be an abuse of the district court's discretion if he only ordered screening?
No, Your Honor, I don't think that we would be here today if he'd only ordered screening and maintained that the prosecution could go forward. What this case represents.
Let me just follow up on that. I'm sorry. Does the record establish that a conflict existed, so this prosecutor had to be removed, but not a conflict as to the whole office?
Your Honor, I don't even think that Bridget Barnes had a conflict, and I would direct the court to a New Mexico case, State versus Robinson.
But under the abuse of discretion standard, which is we give a lot of leeway to our district court judge. I mean, could this record under an abuse of discretion standard support that the young lady had a conflict, or the woman prosecutor, the prosecutor had a conflict, but the office didn't, under the untenable standard?
I think that the district court, and this goes back to your early question, that the order just says that they're off, they're disqualified. There was no basis. There was no finding by this district court to say that she has a personal interest now in the litigation because her life was threatened. There's nothing in the district court, so in the order from which you can make a determination as to how the court exercised its discretion.
I know in the past we've found an abuse of discretion when the court does not give its reasons for doing what it did. Would one of the remedies be to remand it and require the court to give its reasonings and to consider screening and leave that decision to the court, or do we have to make that decision?
Your Honor, I think that because this is an issue of first impression as to what the proper standard is, I think that it's up to this court to make that determination as to what is the standard by which a court should make a conflict determination. But the case should just simply be remanded because there's no evidence that the entire Dubuque County Attorney's Office was burdened by this conflict.
But I'm saying I agree with you, where it's our duty to decide what the standard is, and I think we're capable of that. But the question then becomes, once we determine that standard, do we then send it back to the district court to make a decision? Number one, did that prosecutor meet that standard? And number two, did the office meet that standard? Or can we even decide those issues under this record?
Well, I think that you can decide the issues under the record, and that's why I would direct the court to look at State versus Robinson. It's a New Mexico case that has fairly similar fact pattern to this, where the defendant threatened the life of the prosecutor. And so the court made the finding that it was a two-step approach. Do these prosecutors who were the subject of the death threat, are they disqualified by the actions of this defendant? And the court in that case said absolutely no, there isn't. The fallback was, if these two prosecutors do not have any type of conflict, then the office as a whole doesn't have the conflict.
But this is more than just a death threat. This is a death threat, and then this bond stuff that went on. I mean, it's a little more complicated to say death threat or no death threat. And there are other things that happened after the death threat or contemporaneous with the death threat that causes some concern.
Well, in Robinson, Your Honor, not only were there the death threat, but there was a criminal prosecution. And the issue in that case was whether those two prosecutors who were the subject of the death threat could then prosecute this defendant for attempted murder or solicitation. So I think that if you look at Robinson, it would be instructive. But I don't think that this court, when you look at what the court had before it, it was simply, there's the threat, there's the bond revocation, it's off. If you are thinking that the case should be developed more fully, then I think this court is going to have to give the district court some basis from which it can make a determination as to, how are we going to treat these types of conflicts? And I see my time is up. We request that the district court's order be reversed.
Thank you, Ms. Trout. The case is submitted, and we'll now hear the arguments in State versus Lopez.